Hello out there, my name is Laolu Akonde and you are on to Inside Sources. Here is my take for today entitled Ruling Party Governors as Busybodies in Off-Cycle Elections. The PDP started it, APC perfected it. Now off-cycle elections have become national invasions funded by state money. So yesterday, August 15, the people of Osun went to the polls, but in parts of the state, the atmosphere suggested more than a state election was happening. Videos and photos and eyewitness reports circulating online showed long convoys of governors, delegations from other states and campaign rallies before the election, as it were, featuring leaders from some of the 31 states governed by the APC. They have no franchise in Osun State, but they are there nonetheless. This is the latest example of a pattern that Nigeria has normalized. When one state votes out of the season, the entire national political class relocates there. Now, the former national chairman of APC, Saliu Mo Lukman, who is now working to redefine Nigerian politics, spoke about this when I asked him the question on Friday's edition of Inside Sources. Lukman said the mass mobilization of governors around off-cycle elections reflects the weakening of Nigeria's political parties and the growing influence of governors in party affairs. He blamed the collapse of party funding and the rising cost of elections, which increasingly favor candidates with personal wealth and access to resources wherever they may be found. I added that. Now, according to him, now I'm quoting, party administration has been weakened so much to the extent that those who are supposed to be taking instructions from the party are now the ones giving instruction to the party. And these are part of the things we must address, he said. He continued, I'm quoting again, governors come in and use state resources and go with the cash, which means that election financing is basically more or less driven by the amount of public resources being invested in the elections, mostly by the governors, unquote. That's a honest politician. Now, what these governors do is simply a sham, and there are a few implications. Number one, it's about power for power's sake. The evidence that we have is that Nigeria's political elite are less concerned with the power being used to achieve stuff for the people. They are more concerned about holding power, getting power. Power is treated as an end, not a means. It is used to capture more power, more resources, and more influence ahead of the next election and for personal aggrandizement. In this Fourth Republic, it was the PDP that started this jamboree, but the APC has continued the charade brazenly. PDP governors camped in Edo, I remember, in 2006 to defend democracy. APC governors did the same in Ekiti and Osun between 2018 and 2022, calling it party solidarity. Different parties, identical conduct, both uninspiring. Now, scores of governors will leave their state in a week when only a state, just one state, is on the ballot. As for yesterday's election in Osun, it will seem to APC that losing Osun is being seen or will be framed as losing momentum for 2027. That may be right, but it doesn't justify the behavior. The second point is ordinary people are used as pawns. In this arrangement, ordinary Nigerians, including those drawn from outside Osun, become pawns, and the public gullibility is largely exploited. Youths are hired for mobilization, civil servants are reminded of the benefits and who signs their salaries, including extra pays. Communities are told development depends on aligning with the center. Anger is manufactured so that accountability is never demanded. For instance, on X yesterday morning, a young chap, ostensibly from Imo or Edo State, posted a video of himself in Osun, lampooning Davido and Governor Adeleke. and claiming delegations from those two states had come to Osun to teach Adeleke and Davido a lesson. He recorded all of this with the police escort vehicles of governors visible in the background. Yet, after the ballots are counted, the same politicians who told supporters to fight often reconcile and switch parties. In 2025, several governors who spent years publicly attacking each other defected across party lines. The elites switch parties, share board appointments, and take pictures with giddy smiles. But ordinary Nigerians are left with the division, disappointment, and sometimes bloodshed. The gullible majority is always taken for a ride by Nigerian politicians. Yesterday's opponents become today's allies because ideology is secondary. If ideology sways anything at all in our national life and politics today, your guesses are as good as mine. It is all about access to federal allocation, and federal cover has become the primary resource. So we have to ask the question, why is no one challenging this? Yesterday morning, Professor Chidi Odinkalu raised the core question on X regarding Osun Decide of 2026, what happened yesterday. He alleged that agents of violence who do not have a vote in Osun State, now I'm quoting, have been brought into the state to intimidate innocent indigents and derail the peace in the state, unquote. He's right. And he tagged DSS, EFCC, police, Nigerian Army, Defense Headquarters, Situation Room, and INEC, questioning rightly whether they were seeing what was happening or not. And so the question is, under what law can a sitting governor abandon his own state, travel to another state with his convoy and security detail to influence or intimidate voters in that other state, such as Osun yesterday? If this is lawful, security agencies should say so publicly, and if it's not, they should act against it. Silence is simply complicity. And this is not about one party. APC and PDP are all involved. So how do other democracies handle this? What Nigerian governors are doing in Osun is not unique. What they do all the time during the off cycle is not unique to Nigeria. That's for real. Now, similar practices exist elsewhere, but the difference is the scale, the brazenness, and the fact that in Nigeria, it has become an institutionalized impunity. In Kenya, governors camp in counties during by-elections with county vehicles and money. The electoral body there does complain, even though their sanctions are rare, but they complain. In South Africa, the ANC deploys government ministers and premiers to municipalities for by-elections, but these are party officials, not provincial government convoys blocking the roads. The electoral body in South Africa, that's the IEC, is also considered stricter in imposing consequences. Beyond Africa, presidents and governors in the United States campaign for candidates, but they generally use campaign funds rather than state resources. In India, chief ministers act as the star campaigners, but the Electoral Commission in that country restricts government helicopters and advertisement close to voting, and they can disqualify candidates for the misconduct. The difference is clear, therefore. In other countries, institutions push back, and there is no impunity. Nigeria's problem is threefold. First, we have fused party and the state. Elsewhere, people campaign with party money. In Nigeria, governors campaign with state money, and they call it solidarity. Second, in Nigeria, our institutions are weak. INEC, police, and DSS, they watch all of this and do nothing for the most part. In countries such as India and the United States, this kind of conduct can attract consequences. Third, in Nigeria, there's always a big national stake, which is why we are talking about restructuring, because governors control so much money, and 2027 starts now with the Osun local election, and therefore you see the kind of invasion that Osun saw last week. In conclusion, the conduct, like I said, is not invented in Nigeria. Big men campaign in small elections. This happens everywhere. What is unique in Nigeria is the impunity. In Kenya, the conduct is shamed on television. In India, the Electoral Commission can issue a notice of warning. In the US, people can be sued. Even politicians can go to jail. But in Nigeria, Professor Odin Kandu had to tweet and tag 6 different agencies asking, are you seeing all of this? This governor's jamboree is not grassroots politics. This is the weaponization of incumbency, which was institutionalized by PDP, and now APC is replicating it. Now, both parties will condemn this behavior when they are out of power. But when they are in power, they do the same thing. What a shame. But Nigerians deserve an election that is about human capital development, infrastructure, and jobs, not about which party flew in more governors to harass the situation. Let's tell the governors, stay in your state and govern the state. Let the party do the work. Stop spending state resources for election with such reckless abandon. To the security agencies, please enforce the law impartially. A voter's franchise should matter more than the governor's siren. To Nigerian voters, your vote is not meant to be rented out. Don't fight also your neighbor because of politicians who will tomorrow become allies. Demand accountability instead and call out impunity. Until we criminalize the use of state resources for election and until security agencies act without fear, Nigeria's off-cycle elections will remain national invasions. And people will keep paying the bills. That is the ordinary people. How? With public money, which the governments are spending. Second, with bad governance, which is a result of this kind of behavior. And third, with our democracy. Because when the local elections become a national invasion, the potency of the voting card is weakened by the intimidating power of the governor's siren. There you have it. Inside Sources goes full blast right after this. Welcome back to Inside Sources. In this segment, I'm going to be looking at 3 major issues. We're going to look at the laws that affect campaign funding, especially because of what we have seen many of the state governors in Nigeria do, using state resources, even state convoys, to go and influence an election outside of their state. We're going to talk about, what laws are in place or what kind of laws ought to be in place, especially when we compare that situation to what happens in other countries in Africa and beyond. We're also going to have, we're going to have a conversation on the call of the National Human Rights Commission that Sheikh Yahya Jingri should be arrested, and also Senator Francis Fadausi should be arrested for the comments that they made in different circumstances. That was the call of the National Human Rights Commission. We're going to discuss that. It's also a legal question. And the third legal issue that we're going to be discussing today is the fact that the ADC presidential candidate, former Vice President Atiku Abubakar, on Friday personally went to court here in Abuja to open up, the issue of the claims that of forgery against the sitting president regarding his documentation with INEC in the past. To join me in those important discussions, which has legal dimension, is a leading Abuja-based lawyer who is also an active public commentator, Mr. Ibrahim Wali. Ibrahim, welcome back to Inside Sources. Thank you so much, Mr. Laolu. This feels great once more, and I'm pleased to be here. Thank you so much. Let's start from some of the things that we saw in Osun yesterday and the build-up to it, which normally happens during off-cycle elections. Both parties do it. I made this point during my take that you have governors, and then actually, I talked to me about governors, but hey, in this particular instance, even the Senate president, I'm told, was also in Osun. They camp in the place, they bring resources, they bring their convoys, ordinary citizens see it as intimidation. What are the rules around how you fund campaigns? Why is it that it is easy for our governors, in particular, to spend state resources? I mean, those convoys, at least that we can see, they are state resources, and then there are claims that they even spend government money on campaigns. What does the law say, Ibrahim? So thank you for this germane question. Indeed,
To start, it is condemnable, saying that state resources of that nature, are being pulled towards electoral satisfaction. But yes, the Electoral Act actually provides funding provisions that seek to regulate or that regulate some of these excesses or a lot of these excesses. For example, if you look at Section 99, subsection 2, it is very clear of the Electoral Act of 2026, it is very clear that no state apparatus shall be used for any political candidate or any political party activities. Now, how do you define state apparatus? So when they say that state apparatus should not be used, basically anything that is connected with the state, anything that is for the state and of the state shall not be used whatsoever in any elections for any candidate or any political party. So
our laws, is that clear?
It's clear to that extent. So where you find governors of a political party or the ruling party or governors of other states, using their official convoys, going with their official officers who are being paid from the coffers of the state, and they are there to also lend their hands because they will go with their essays, with their PAs, who are actually part of the apparatus that the state provides them for their respective offices. They go, and then, just like you say, they even fund these campaigns. And Section 96 of that same law says that, okay, after every elections, political parties, have to, and it's a must, make disclosures as to, their campaign funding and their campaign excesses. I think it is in the failure to actually hold them to this post-election account, that leads to all of these, excesses. But yes, the law, to some extent, tries to regulate, the financing of the political party, how much an individual can, INEC has, the power to say, okay, this is how much an individual can donate, and, donations over certain, thresholds must be made public, they must be disclosed so that, INEC can trace and track, also to ensure that, state apparatus is not being used. But, regarding your particular question, I think it is highly condemnable. It is also against the law, for any state official whatsoever, be it governors, senators, whatever it is, to go to or to use any state apparatus or any state, institution or any state machinery or state funding to promote elections for an individual or for a political party. So I believe that, that acts of convergence, because you see them with their official cars, with their official security. It's so difficult for state governors to leave their state to another state or to, in fact, prosecute elections in their state as it is, to say that, okay, you are not in breach of this particular law because you go with your security officials. And if you look at it, you would even ask, okay, who is even funding the trip to begin with? Maybe, they are being paid from the state, ESTA codes and all these things. So it's wrapped in, proper state regalia, but then it is, geared towards the satisfaction of a political party or a political candidate, which is in direct contrast with the law. So I believe that it is condemnable and it is against the law, and I believe it's a concern worthy of being raised and being addressed critically.
Okay. Very important, because, I know that in the United States, for instance, a state governor cannot use state resources to go and campaign. As a matter of fact, they can't even use official helicopters and planes, except the president, who must fly Air Force One. But even the president, it will be debited.
Yes.
He'll be debited.
He'll be debited for it.
He'll be debited for it. And then in India, premiers, and they call them, I think chief ministers, they can also, as politicians, go and get involved in campaigns because they say that they are star campaigners, but they cannot fly official helicopters, and they cannot use their own convoys,
Section
to block.
96 even says you can't even use, state public places, places that belong to the state, for example. And you see it a lot of times, they hold their meetings in government houses, their political party meetings in government houses. So the law is very, clear in that regard. You cannot use any public apparatus whatsoever to promote an election.
Yeah. So the impunity in Nigeria is very blatant.
It's because it's brazen. Because you would see them with their sirens, with their office. And in fact, they don't even try to hide it, because even in their interviews, you'd hear that, okay, we are here, like, the governor of Edo State, for example, he will come out and tell you that, they would ensure that they deliver, their candidates in the other state.
Even on Thursday, sorry to interrupt, but just to back up what you said, on Thursday at the mega rally of APC in Osogbo, the chairman of the Nigerian Governors Forum, who is also the governor of Kwara State, also said that the reason APC lost in 2022 was because there was not, I think he said, the right support from the federal, but that now that support is there.
So it says support from the federal government. It doesn't say support from the national organ of the political party.
Yeah.
So when you say the federal government, who are you referring to? You're basically referring to
that was what the government said it,
yes.
at the campaign. So it's the level of the blatancy of it, the brazen way it is conducted. It just, I find it, and I have served in government, and some of these things, was noticed, but. I think it's something that we need to start talking about openly so that we can have some kind of pushback, because it also influences the way the vote goes. It has the capacity. For instance, the people in the state could be intimidated.
Most definitely.
With
a lot of convoys and security officials, you most definitely be intimidated. And, there are laws as to who is even allowed to go to polling units and stuff like this. So it's unfortunate, like you said. It's unfortunate.
Well, anyway, so, that I wanted you to respond to that. But let's go to our main issue. I wanted to start by referring to the statement of the National Human Rights Commission that was made this week. Which I think, by the way, quite very right of them and quite courageous, because it's a federal government agency also. I'm saying that, look, the DSS and the police, I think they were very specific, ought to arrest Senator Francis Faddaunsi and Sheikh Yahya Jingri. Now, Senator Faddaunsi, for the viral video where he was said to have asked people to go and kill members of an opposing party, and the sheikh, where he said that that others are infidels, that if they can't accept a Muslim ticket, that they should leave Nigeria, and all kinds of stuff. So let's take it one by one. What is your own take as a lawyer? Because the National Human Rights Commission, the guy is a lawyer, it's like it's one of the legal institutions, and they're making this call.
First of all, I would, in addition to what you have said, further commend the National Human Rights Commission for actually coming out, boldly to, raise these concerns. I agree with them. They are thoroughly justified. But I would like to begin with, the constitutional basis of, freedom of expression, so that is established. So you have your freedom of expression, and going further to Section 38 of the Constitution, you also have your freedom of thought, opinions, and freedom of religions, and holding your opinions regarding your religion, and then, belonging to any religion of your choice. But the Constitution also, in recognizing the need for our unity, cohesiveness, and oneness, goes on to say, in Section 24, that, you have a duty as a Nigerian to ensure that your utterances and your actions do not injure, or do not malign, or do not cause, or seek to cause any, violence, or any breach, or any issue, even emotional, against another Nigerian. So, the National Human Rights Commission is justified also under the doctrine of prevention jurisprudence, in the human rights, because under human rights, you do not wait until something happens, even if you have an inkling that your rights or rights of the people is going to be trampled upon. You have the rights to approach the court. You have the rights to, carry out action based on that, probable cause. So I believe that it is really unfortunate that, we are still talking about this, and especially it's coming from, public figures who, you ought to know better, especially, for example, like the senator who was once, who represented the country at the highest level, who passed these laws that I'm about to enumerate. Because if you look at Section 42 of the Constitution, for example, it says, clearly that, you should not discriminate against any other Nigerian, on the basis of either ethnicity, tribe, religion, on the basis of, even sex, gender, on the basis of, political affiliations or political association or political party. So these are laws that, they have, they we were presumed to, be knowledgeable about, because, they are our lawmakers, they pass this law, they do. But also Section 101, just to show you that, this is the position of the state. Section 101 of the Electoral Act is very clear that it is illegal, it is unlawful in Nigeria to base any political promotion or any political campaign on religion. Religion or ethnicity or regionality or tribalism should never be the basis of promoting an election or promoting a candidate or or a political party, it's there in the law. It's a 2026 Act, Section 101. Right. And 96 is also clear that, you should not use, religious basis, to also propagate, politics. So politics should, political promotion should be based on competence, should be based on policies, should be based on character, personality, and not, so it's expressly prohibited. So the National Human Rights Commission is justified in calling, these two people to order, or rather in calling the law enforcement agencies, to rise up to their constitutional demands, because the constitution is clear that the protection of lives and property in Nigeria is vested on the government. So the NHRC is right, because these are very condemnable statements. These are condemnable statements. Politics should be driven by ideas, not by identity. And especially the law is clear that where you promote politics based on identities, because if you look at the Sheikh's interview, for example, the basis of his discussion, it wasn't just an opinion, but it was an electoral prompting, it was prompting, so-called prompting, Muslims to ensure that, they go ahead and get their voters card and ensure that, they vote. So he pitches, there's this us versus them. Rhetoric that it pitches. And if you look at the history of, political violence in Nigeria, it has all of these elements, religious elements, tribalistic elements, sectional elements. So it is highly condemnable. So I believe that there is a basis for investigation indeed, especially under Section 101 of the Electoral Acts and Section 96 as well. But under, possibly under other laws, because if you look at the Cyber Acts law, for example, the Cyber Crimes law, as much as we disagree with certain aspects of it,
it's in operation.
Yes, it's an operation. It also, prevents hate speeches, and based on religion, based on, so any speech that is likely to cause violence or likely to enrage emotions. The law is clear. The law uses emotions, so it's not as if, it's just violence. So it's the likelihood. As long as it is likely to cause, then there is a basis for investigation, and I believe that the National Human Rights Commission is wholly justified, and I call on these actors to ensure that they lead with caution, because it is unfortunate, and we are going into 2027 elections for crying out loud. Nigerians are suffering all the same types of problems, regardless of religion, regardless of ethnicity.
There are more important things to worry about.
There are more important things, standard of living, the cost of livelihood, the unemployment rates, all of these things, the indices are on the negative side, so these are distractions. These are distractions, and I believe that NHRC is right.
It's right. So you agree with NHRC
Absolutely.
that they should be arrested, or at least questioned. Well, in the case of Fadansi, he was questioned, but we've not had any report. As a matter of fact, in a BBC interview afterwards, the Sheikh said that he has no apologies.
Sadly, but I believe that there's a basis for investigation. It would not depend on, the respective law enforcement agencies to look at the facts, it would elicit, the facts, look at people's reactions, and then marry it with, what the law says. And, therefrom they can establish whether to prosecute or not. But I believe that a prima facie case for investigation has been established.
Okay, all right. Finally, let's move to the third issue, which is this case. On Friday, the ADC presidential candidate, former Vice President Atiku Abubakar, went to court. And, I will read what Al Vanguard reported. It says, 2027, Atiku asked court to disqualify Tinubu over names and certificate controversies. So the former Vice President went to court and said, look, the NYSC certificate of the president has, there's a difference in the name. And it's also saying that there has been a previous time when the president made certain claims to INEC, which is saying that he should come and clarify, what happened. What is your take on this this issue? And, why was it important? Maybe you start from that. Why was it important for the former Vice President to personally go and swear to an oath on this?
Okay, I believe that the former Vice President, Atiku Abubakar, had to go and swear on oath because he's a party in the suit.
Okay.
So, being the party in the suit, being the complainants or one of the complainants, he, had to go in and, swear to the affidavit that would attach the process. It's an originating summons, that, presents, a lot of issues for the court to interpret and determine.
So what's the meaning, what's the implication of originating summons? Since
So it basically means it's going to be decided on documentary evidence. That is, there's not going to be oral evidence. Nobody is going to be examined or cross-examined in court physically. Okay. It's going to be fought to its conclusion only on paper documents and then the provisions of the law. So that is basically
there will be no witnesses.
There will be no witnesses.
So when they say originating summons,
yes,
that is what it means.
Yes. So the affidavit that he deposed to, those now constitute the evidence that he would otherwise have given orally in a writ of summons proceedings. Right. So that's now the evidence basically, and whatever exhibits you attach to those affidavits. So that's the bundle of the evidence before the court, bundle of the facts and evidence, which the court is going to use to. So
that means that there will be no witnesses called.
There will be no witnesses called.
So they're not going to call him or call the president as a witness in this case?
No.
So, but the lawyers will still go before the court.
The lawyers will go and
argue on the basis of the documents.
Of the processes filed and the exhibit attached to the processes.
All right.
That is what an originating summons is. So that is the extent to which he's going to participate. He's not going to go to the court physically. But I believe that it is actually a very grounded lawsuit in the sense that it has serious constitutional elements and implications, because Section 137 of the Constitution is very clear that non-qualification, that you cannot be qualified, you cannot be a president or the president of Nigeria or run for presidency of Nigeria if you are not duly qualified. And one of the basis for the qualifications is your certifications, right? So that is your school certifications, obviously. Under Section 26 is also clear of the Electoral Act that candidates must submit these documents to INEC, and also INEC has the power to also accept these documents. So I think that it's important and imperative to understand the basis or the tactics of the lawsuit itself, in the sense that the lawsuit is actually claiming on one hand that we have served INEC with a notice to give us all the documents that the president has submitted to it, which is, legal under Section 29 of the Electoral Act, because any person can actually, apply to INEC for any information regarding any candidate, because immediately you submit it, it becomes public document. Yeah. And then INEC has failed or refused to give us these documents. That
means refused to give Atiku.
This, yes.
So former President Atiku has requested.
Has requested from INEC, yes.
But INEC has not responded.
Has not responded. So we have now taken INEC in court together with the president to, on one hand, compel INEC to produce these documents, and then for the courts to now look at this document and ensure that these documents, are proper. And where you find that the documents are not proper, to give a legal, to a remedy, which, one of their prayers is obviously to declare that he is not competent or qualified. The president is not competent or qualified, to seek elections for the office of the presidency. That is basically what the lawsuit is about. But obviously there are going to be a lot of arguments in the sense that, questions will be raised as to whether, Atiku has the legal standing to go to court at this stage, because obviously I'm sure you know that the legislators thought it fit, to amend Section 138 of the Electoral Act, or to introduce it such as to remove, questions of qualification. I'm sure that, you remember when the Electoral Act was passed, we had 4 grounds upon which, after an election has been, conducted, you can go to court, qualification being one of those grounds, but now they have removed qualifications. It's now non-compliance with the Act, and, the respondents, did not have the majority of votes. Okay. So they have removed the issue of qualifications entirely.
So they left it into the hands of the party?
So they left it into the hand of the parties, in the sense that if you look at Section 285 of the Constitution that deals with pre-elections, it says that, only an aspirant, especially subsection 5 or so.
In the party?
Yes, who has been part of a primary, can have, the course of action. But it is also arguable, and it is argued, and I agree with the argument that the Constitution cannot create a condition that the legislator is now going to sort of, render unenforceable. Because if the Constitution is saying that you must, qualify with based on these grounds, and the Electoral Act, referred to those grounds in the Constitution as to, you also must. So the fact that it has been removed, so the lawsuit, is asking very cogent questions.
So
are you saying that there is no judicial remedy after this stage? Is that what you're saying? And then if you look at Section 285, subsection 14, sub J, it says that any aspirant can challenge INEC, can take INEC to court on the basis of, a nomination of candidates or on the basis of compliance with the law. So this is the angle Atiku is trying to come from. Okay, being an aspirant, because it's the constitution now, it didn't constrict it to either aspirant of any political party, any aspirant generally, and that is why part of why I believe he had to go and depose to it personally. Okay. Any aspirant can challenge INEC as to its duties. And if on one hand you are saying INEC failed to scrutinize the documents, INEC failed to produce the documents, then wrapped under that jurisprudence, you are now filing to say, okay, what is the basis of this failure before the court? And then if this is established that indeed false information has been, put forth, has been supplied to INEC, what will now be the judicial determination? So that is the prayer. That is basically what the lawsuit is saying.
Interesting.
Yes, so I agree with the direction of the lawsuit.
So your view, Atiku does have, there's something for the court to settle.
There's definitely something for the court to settle.
The question I wanted to ask is, then follow-up is that, so, because this is not a new matter, and I think even during the election petitions of 2023, that some of these matters came up, and the Supreme Court has ruled on it, So what is new in this case? I wanted to consider that. So the judgment of the Supreme Court, when this was raised, what does it mean? Okay, what does that judgment mean? So
you have to understand it in terms of the electoral cycle, for example.
Right.
So this is an election season, right? There are laws as to how, this season is supposed to be governed. So part of it is that candidates are supposed to submit their documents. So the document that I submitted in 2023 might not be the same bundle of documents that I submitted in 2027. Okay. And that is part of why, they are saying INEC should, disclose these, documents. So it is based on the basis of this fresh disclosure, on the basis of this fresh submission and fresh nomination, that the suit is been prompted. And I don't think that the Supreme Court in 2023 put a lead, final lead on, these questions. I think that, it was the substance itself of whether or not the documents, are forgeries, or whether or not the documents, were false or not, was not concluded in that suit. So it's still an open issue. But outside of that, this is a new issue completely that has to do with the submission for the 2027 general elections. And that is why one of the prayers is for INEC to produce all the documents that the president submitted for his nomination. So this is a fresh issue entirely that is unconnected with the position of the Supreme Court in 2023.
Interesting.
Because you might have submitted different documents, or maybe withheld documents that, because, for example, your university certificate, it's not a must for you to submit your university certificate. And I want to believe that he did not submit his university certificate that cost the
opera.
Yes, so that's why if you look at the Atiku suit, it's more based on the NYC aspect of his documents, not even the Chicago certificates, because he has the right to decide not to submit that as long as he submits what is necessary. So that is why they first of all want to know what is even submitted, and then if that is the case, that this NYC document that was submitted is forged, the court should look into it, and then the court should decide ultimately what should be the. Obviously, they have their own prayers to disqualify.
So what do you think will be the response of the legal team of the president on this? What would be their argument? Oh,
local standard and jurisdiction. The court does not have jurisdiction to try the matter because it is a pre-election matter. So it now goes into how you define pre-election matters, whether Section 285 that I mentioned, who says any aspirant can, of the Constitution, who says that any aspirants can, in defining pre-election matters, that any aspirants, that feels like INEC, did not obey the law in nomination of candidates.
Whether they have a right?
Yes, so it's now to define it as whether that, allows aspirants from other political parties, and also local standard, obviously, they would make the argument that only people who have, only those who have contested with the president in his own primaries, but this is where, the constitutional arguments, becomes very necessary, because if there is a law, for example, that even, makes this provision, so is it going to be against Section 1, subsection 3 of the Constitution that says no other law, shall conflict with the Constitution and the Constitution shall prevail? And are you now saying that if, the party decides not to challenge this, then we don't have any recourse, which takes us back to the constitutional question of Section 137? For the grounds of qualification. So I also am eager to see how the court...
Okay, so sorry. So on the question of jurisdiction is to say that the court is not a proper venue.
It would be that, it's a pre-election matter. The party, does not have local standard. Therefore, the court does not have jurisdiction, and yes, venue as well, based on it does not fall within the fine confines of the
So what's the law about pre-election matters?
Yes, so the law, there are an array of sections that try to define what constitutes pre-election matters.
In the Constitution?
In Section 285, Section 285 generally deals with pre-election matters.
Okay.
In the
Constitution?
In the Constitution itself. Before you now go to Section 29 of the Electoral Act, which says that an aspirant, that it's now the Electoral Act that actually brought that, an aspirant who contest in the same political party as yourself, but the Constitution just says that an aspirant who believes that INEC, that is Section 485.
The Constitution doesn't limit it to the aspirant in the party.
The Constitution is not limited to the aspirants in the party, but the Electoral Act does.
But Atiku is not an aspirant, he's not a candidate. Is that an issue? It's a candidate now, not an aspirant.
Yes, so maybe the only issue would be maybe as to a matter of time, 14 days after the action that you are complaining about, for pre-election matters in the Constitution, you must have filed within 14 days. But if he's saying that, I applied to INEC, and that is why I'm making an emphasis on this. So within the 14 days of my application to INEC is, when my grievance arose in the last 14 days because I had already filed a notice to INEC and they have failed. And by Section 284 sub 14B, I have the rights to actually, go to court where INEC fails to obey, the law within any, constitutional confines or any law, that National Assembly has passed. So that would be, but I believe that it's a tricky one, but that's why, you submit it to the court and you allow the court, with its wisdom to sort it out.
Do you think that this matter is going to go all the way to the Supreme Court?
I believe so. Because I don't think either any side winning or anything the court decides is going to bode well for all the parties. So I believe whether the applicants get judgment or the respondents or the court might even give something that is legally obscure for both parties. So I'm very confident that it's going to get to the Supreme Court.
It's interesting because we are in August and the elections don't hold until January. So,
but they can expedite it. As long as the court agrees it's a pre-election matter, then there is a time limit within which.
But in your view, is it a pre-election matter?
I believe it's a pre-election matter. Because it has to do with
And it's not constrained by time.
It depends on when the submission of the. It depends on when what you are complaining about precisely arose.
Okay.
Yes.
All right. Okay. So my final question on that is that the point that Atiku is making is he says based on Section 137, in subsection 1 or so, I'm not sure, that as anyone which is about qualification to that anyone who has submitted, I think he said, I don't know whether it's forged document or forged certificate.
False information.
Or false information.
Yes.
Okay. But is it document, because there's a difference between information and document.
Okay, there are two wings. So whether you submit false information or you submit a forged document, both of them are covered under Section 137.
So Section 137 also includes forged information.
Forgery, yes. False information.
Because if you write something down,
false information and forged documents, all of them are
both of them are
provided for in the law.
Because discussing this with a lawyer, with a senior lawyer previously, several years ago, the argument was that, if a document is not involved, then that is not forgery. Because what happened, and then I'll let you respond. What happened here is that, what Atiku is arguing here is that the president submitted information sometimes, I think, in 1999, and then those informations are no longer being used. For instance, where he went to primary school, secondary school, and all of that. So that is, so the argument is that those information are false, because if they are not false, it will not be, it would have been represented.
Yes.
And of course, people have also made claims that, we found out that what the president said about his primary school, about his secondary school is not correct. Okay? So subsequent elections, the president stopped talking about that. Is that forgery or not, in your view?
It's different. Like Section 29, subsection 5 of the Electoral Act is very clear that where an aspirant submits in completing his forms, gives a false information. So this would be, obviously there are aspects where you give information as to, okay, this is the school that I went to, this was when I graduated, this is who I am, this is who I'm not. So if you give any false information, any other aspirants can, apply for that information for you to be disqualified based on that ground. But the Constitution is also clear that if you submit a forged document, so I believe it's different. Forged documents, a document that does not belong to you, a document that maybe, does not have the legitimacy that it claims to have, is forged, it's not, but also in filling your INEC forms, and that is why he said, EC001, that is, in filling your INEC form, if you give any false information, because don't forget, you are going to have to swear an affidavit as a candidate, as to
say that this information that
you are giving is so already you place yourself, under the scrutiny of the law. Well, not jeopardy. I mean, let's presume, but you place yourself under the scrutiny of the law, which means if those informations turn out to actually be false, that means you have actually perjured yourself. You have lied before the court, and it has its.
So all those when an aspirant or a candidate of a party fills an INEC form, it is you are under oath.
You're under oath. You're under oath. It is always attached with an affidavit of verification of facts, or an affidavit verifying that the facts and documents that you have put forth are indeed what they claim to be.
All right. Now, so when give you an instance. So if I give the information and then I stop giving that information, is the onus on the person who is saying that it's false? Because
yes, the onus is on the person.
Because if it's not required, if I give an information that is not mandatory, and then I now later withdrew it, so my opponent is saying that I withdrew it because it's false. That's his own argument. Now, how is that proven in court? Because I will just say, or I could say that, well, that information is not required and I have not submitted it.
That would be a grounded justification. So I think that the scenario where this plays out is if, it's a yes or no question, or it's a one thing or the other question. So previously you've been claiming, okay, maybe in the portion, say for example, have you ever been arrested? Keep saying, yes, and then, maybe you now leave the place blank. You can't leave it blank. Maybe you now say no, for example. So if I can get evidence that you have been arrested and you have been claiming, so obviously you have now given false information because you have changed a position.
Okay.
So for example, if, it's going to be a stretch, but if, for example, there are places where you feel your secondary school information, so, and this is, I guess, where your defense comes in, you just, previously you said you went to so school, and now I did not include it. So it's going to be very difficult for the purpose of that lawsuit or the purpose of that elections to get anything out of it. But if you change any position that you have held previously under a new law, under a new submission rather, to INEC, and then I'm able to obtain the documents and I see that, you are now claiming, not to have, maybe previously you said you did your NYC and now you're not saying you did not, or maybe you said you didn't and now you said you did, So if I can bring that, those two together. But in the events where you fail to, and it's not a necessary document, it's going to be a lot tricky because you cannot establish that falseness.
Because the question now is that if the president says that, okay, in the 1999 form says that, okay, I mean, these are the schools that I went, and then, in 2003, he's not saying it, and we have the story that, somebody was the one that filled those forms, and it was the person that filled those forms that made those mistakes, okay? So if Atiku is now coming up to say that, look, what you said is not true because for social reason we found out that school is not whatever, how do you prove that information is false? If the guy is saying that, look, I'm not required to even give this information. That's what I'm trying to ask you to address. Is there a way to prove, indeed, without the man, especially now that you said that it's an originating summons?
It's an originating summons.
What kind of documentation can Atiku now bring to prove that what the president wrote in 1999 is not correct?
Well, I think this is why the first basis of his case is for INEC to even produce
that
the form and whatever the president has submitted
from 1999,
so that they can now confirm truly what was said, what is being said. Because I agree with you, as long as the document is not being put forth, they didn't submit the document subsequently with INEC, it's going to be difficult for the purpose of that election to, you know, prove that the information provided is false. So on the basis of information, it has to do with, you know, the information that the president has provided. On the basis of documents, however, you know, if indeed he has put forward any document that is, you know, a forgery, then the court can look at that. Yes.
Okay, so then what about the names on the NYC certificate? So there's a slight difference, you know.
I think one has, was it Bankole or?
Yeah, no, one has Adekunle.
Adekunle.
Yeah. You know, and the other, you know, well, no. So what Atiku is saying is that his certificate, NYC certificate, has Adekunle. And that his name now does not include Adekunle.
Does not include Adekunle.
Well, I mean, what does that mean legally?
Yeah, so it simply means, you know, that, you know, there's a, you know, prima facie, you know, allegation of forgery. You're saying that, okay, it basically means that, okay, on the face of it, you know, and that is why if you look at the lawsuit, it was well constructed in terms of they did not make the conclusion that this document is a forgery. Yeah. But they are saying that, okay, you know, there's a question mark on this document. So, you know, after they've made that, it will now be, you know, the duty of the defendant to come and, you know, justify
and explain.
Either explain or, you know, find a way to. But I don't think we'll get there because, you know, all those objections as to jurisdiction are going to drag out the.
Okay, so that you probably not get to that point, because one of the things that Atiku is saying in his originating summary is that, look, if a Nigerian, if a regular Nigerian, you know, gets an NYC certificate, and you have this, you know, issue about the names that, you know, such a person is likely not to get a pass. How does that sound in the law court?
Yes, there's already a presumption of if it appears irregular, there's a presumption that it is okay. There's a presumption of regularity, right? You can raise an issue, but the presumption is that the document is irregular. You raise an issue, and then, you know, the other party now has the, you know, you can now rebut that presumption to say that, okay, look, you know, this is not just, you know, this has to be explained, you know, because it does not. So also it ties down to information that has been put forth. So if you put forward an information and you swear that your name is, you know, this and that, and then the document is saying that that is also not your name. So, you know, it ties to whether, okay, the information, either the information you provided as to your name is not correct, or this certificate is not correct. You have to choose one. So is this your name truly, or is this certificate yours? And then, you know, they have to now come in with their defense. Interesting.
So, you know, overall, how do you think this is going to end in your own view?
From my experience, obviously, you know, of electoral matters and the Nigerian court, I believe that, you know, at the trial court, you know, is going to get stuck in the, you know, jurisdictional questions. You know, the court might determine, you know, that maybe Atiku does not have the standing to pursue the case. But I believe that
and then they will now go to appeal. They will now go to appeal.
Yes, but I believe that, you know, what the court should do is try to also make, you know, findings on. I believe that worst case scenario, you know, he has the local standard to actually challenge INEC to produce those documents. So I want to believe that the court, you know, is going to determine on that leg of the case, validity on that leg of the case. Okay, INEC is actually in breach of the law for failing to, you know, abide by Section 29, which says that anybody can apply to get these documents. But on the second leg, you know, as to, okay, the court should look into the certificates, the documents, and then to, you know, disqualify the president. I don't think that the court is going to agree to go into the substance of the case, but I would have loved for the court to take that their bites at the cherry, because this is not just, it is a constitutional question if you look at it. Outside of, you know, all the technicalities around, it's a constitutional question. The provision is clear, Section 137. And for you to run for this office, you have to be qualified. So I think, you know, this is not a question the court should dodge, you know, but the court should find a way to...
But your prediction is that, you know, this is going to be dog. It's going to be stalled on the basis of technicalities.
At that stage, yes.
And then, of course, you know, so they will drag the technicality all the way to the Supreme Court.
Because obviously it is what you take to the Court of Appeal and the Supreme Court that is...
because the stakes are very high, you know.
The stakes are very high.
The stakes are very high.
You're not confident that our courts can bite the
well, you know, it's just, the stakes are just too high, you know. And by the nature of our politics, you know, especially in the last several years, you know, we've seen quite some kind of here today, there tomorrow, you know, that you really don't know.
So definitive position.
I mean, I don't think anybody can make any.
That's my prediction, because I think even in 2026 recently there was a lawsuit. I think it had to do with, was it Nwoko? I'm not very sure. But I think the court also relied on, the fact that he did not participate in the primaries to say that, okay, you cannot question the qualification of the other person. So I believe that, the Federal High Court, would tend towards, a narrow interpretation of the word aspirant.
Interesting. And we don't know who the Federal High Court judge is going to be yet.
I don't know. I think it has not been assigned. It has just been filed, but I'm not sure.
Because that's also going to be very an important. That's going to be an important determination because we've seen all kinds of judges. Yeah, of course you should. Because you are a lawyer. I'm not. I'm going to not mention anybody's name, but we've seen quite a lot of.
Indeed, the confidence in the judiciary, especially in the Federal Court, is a bit low. Yeah. It's a lot low, in fact.
So one of the first indication is who is assigned. The person who does the job of assigning is the Chief Justice.
Is the Chief Registrar, Chief Judge
of the Federal Court. It's going to be very interesting, and we're going to be following it. Thank you so much. Any final comments?
Pleasure is all mine. I think that these issues are they just show the laxity, I think, with which we, appreciate our Constitution, right? So from, campaigning, how difficult, would it be for you to campaign on issues, except if there are no issues to campaign on? Yeah. You are campaigning for the current administration, it means that, you should have, substance to campaign on.
Exactly.
But only where there is no substance, that's when you now refer to religion. But the law is clear that, all these things, and if you look at history as well, all these things, they're not necessary. They are cancers to the Nigerian society. The average Nigerian does not care, I don't care who you are as my president, whether you're a Muslim, atheist, or whatever it is. I know that, I have my constitutional rights, and these are your duties, and I'm going to hold you to account based on those things. And that is what I expect for every other, Nigerian as well. So this question, just tells you, or these issues, just tells you that, we're still, there's still a long way to go, in ensuring, because these are people, a senator, for crying out loud, how bad can it be?
It's quite a thing. And, if you ask a supporter of the president, they will say that, oh, look, these issues have been resolved. Why are they attacking him on that issue? What are they going to do differently? That's what a supporter of the president will be saying. Now, if you ask the supporter of Atiku, they will say that, no, if somebody has told that kind of a lie, quote and unquote, then, if the conscience says that you can't give false information,
it's a constitutional,
there is a constitutional issue, that is an important thing. So, depends on who you speak to and who is talking about the matter. But it is certainly going to be very interesting what we are going to be seeing in the next following weeks. Especially, we're going to be watching out who is the Federal High Court judge that gets assigned to it and how is that going to be handled. And you have predicted that it's even likely that this thing is going to be stalled on the basis of jurisdiction and local standard.
But my preference is for the substance of the matter
to be resolved. Yes, resolved very, 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 very certainly. Thank you so much, Mr. Ibrahim Wali. Thank you for the insight that you've given us, on these three issues. And thank you for always coming to Inside Sources.
Pleasure is all mine. Thank you for always inviting me.
Thank you. Yes. And there you have it, another edition of Inside Sources. Like we always say, Nigeria will prevail. It means Nigeria will win, partly because we will keep on the major issues of the day. My name is Laulu Akonde. Thank you for watching. And by the grace of God, I'll see you at the next edition.